Okay, welcome everybody to the Law 2025 Commercial Property Online Shape the Debate with Anna Newport and Simone Ritchie. So this session is due to last about 1 hour and will cover the latest developments in commercial property featured in Law 2025 online, as well as the pre-submitted questions. If you didn't get a chance to submit a question for this Shape the Debate, don't forget to sign up to the Solicitors Group emails to be alerted on upcoming commercial property shape the debate sessions, as well as free, regular, relevant, professionally curated updates to support you in practice. Now, before we begin, this session is sponsored by Watchman Insurance. If you don't know what that is, Watchman is a specialist insurance policy available only to solicitors, provides insurance for unoccupied properties, and has been revolutionary in changing the way probate solicitors protect their clients' estates by reducing initial pressure on your funds while you're still trying to access the estate and sell the property. Watchman achieves this as solicitors do not need to pay an upfront full premium. Cover is secured with a small initial deposit and continues with a daily premium charge that is deferred until the property is sold or transferred up to a year, with no finance agreements or cancellation charges. It's also available for homes where clients are in care or reduced legal capacity. Getting started is easy. If you'd like to learn more about Watchman, you can contact their helpful team at 01935 389 812 or via their email address enquiries@watchmanservices.co.uk. And if you haven't already, you can still purchase the full commercial property law online today, which will give you full access to the sessions and topics that we will be discussing today. So by way of instructions, first of all, I'm joined by Anna Newport. Anna is a well-respected solicitor with comprehensive background in land law. Her diverse experience has equipped her with extensive knowledge covering most conveyancing topics. She is renowned for her expertise in complex land law and combines her legal acumen with a straightforward approach, serving clients across England and Wales. As part of Law Online, Anna's sessions include reforms and new cases in commercial property law and navigating complex commercial freeholds, including legal strategies for land lawyers. And I'm also joined by Simone Ritchie, who is an experienced property litigator, practicing solicitor, and digital nomad. Simone previously trained and practiced at global law firms and has nearly 2 decades experience acting and advising on a wide variety of property disputes. She's a Legal 500 recommended specialist solicitor in property litigation and dispute resolution, specialising in all aspects of commercial and residential property disputes, acting for both landlord and tenant, as well as squatter claims, rent arrears recovery, dilapidation disputes, and unlawful eviction. As part of Law Online 2025, Simone's sessions include dilapidations in commercial property, claims, defences, and key case law, and break notices in commercial leases, drafting, compliance, and case law. So that is enough from me. I'm going to let the experts start speaking. If you guys would like to start with the first question.
Thank you very much. So the first question we've got is looking at the key risks when we're advising clients on acquiring commercial sites that are held with possessory title. So presuming everybody that's watching this or listening to this knows that possessory title is one of the considered to be a lower class of title. So we can't say for sure that there isn't somebody out there with a better title to the property that you're acquiring. It's complex enough in residential property where people are likely to have long-term knowledge of the land in question when they're coming to sell, and can give appropriate statutory declarations, and we can get indemnity insurance. It tends to be more complex when we don't know what the future use of land is going to be, and where planning can shift, and where options on the commercial viability of land can shift. So possessory title is, really, for most of us, we think it looks harmless enough, get an indemnity policy and crack on. The insurance policies are available across the market and quite easily obtained, but it can present a serious practical and commercial risk to any development. So the title is going to exist because Land Registry accepted an application based either on long possession or on lost deeds. So there might be a former paper owner, it might be the seller, or somebody who's got an unregistered interest who could challenge it. So remembering that insurance only covers financial loss, it's not going to prevent disputes, injunctions, reputational damage if a third party appears with documents or starts fencing off their bit. So we see it a lot in residential property, less so their bit in commercial, but it can happen. From our point of view, I think we should be doing more than just ordering insurance and moving on. So you want to be having a look at the basis of the original possessory claim. So you get your registers, you'll see title possessory. The Land Registry should, if they've not lost everything, have a copy of the statutory declaration or ST1 or however that's been done that was used when the possessory title was first registered. We're going to have a look at whether it's under old rules, so pre-2002, or new rules post-2002, and whether the use that it's got at the moment has been continuous. So you're going to want to be looking at a bit more around it. So looking at access and visibility, so possessory title relating to land use for access, signage, car parking, deliveries, things of that nature, then the risk really is commercial. It's not just legal. So your client's going to be risking losing functional use of a site. It's going to undermine value. And it may render it unmortgageable. I don't personally have an experience of anything being rendered unmortgageable. There's usually a workaround, but if lawyers are here for nothing else, it's for worst case scenarios. So another key risk for me around that point is not telling clients clearly what the risk is here. So not talking to them about their past risk, not talking to them about their transitional risk, and not telling them actually how to deal with title upgrades and how that would work further down the line. So, as with all things, the risks that we're worrying about may never pan out. But the point rather is that we could have a massive issue for clients if they're ill-advised or they buy something and we haven't made inquiries as to what they want to use the land for, and the possessory title could hinder that. So I would also always get a surveyor to do a physical inspection. So we want to confirm there are no encroachments or signs of third-party use. So remember, legal title doesn't always reflect what's happening on the ground. And yeah, I think that probably covers that point about thinking about your risk in terms of not just, oh, we're lawyers, we're sat here, this looks rubbish, get a policy on it. What are the clients, the end users going to do? And then what happens if you've stuffed that up? Is someone like Simone's going to come and sue you? So you can enjoy that no end. And on that note, over to Simone.
I don't really know how to follow that, to be fair.
Don't sue me.
All right, so just in terms of like property litigators, like in an ideal world, I'd like to do the preventative work,
Yes.
okay?
Yeah.
But unfortunately, more often than not, people don't come to us at the right time, and we end up being the ones that have to clear up the mess. So what I would add, I mean, I can't talk about from the transactional side. I haven't got a clue, never done it, apart from like one seat many moons ago. But what I can tell you from being heavily involved when things go wrong, is that my kind of pleading wish for people who are transactional lawyers is to speak to us earlier. And if that will end up saving your clients so much money in time and effort, because often there are things that we see with a different kind of mindset and a different set of eyes, where we turn around and say, hang on a minute, guys, have you thought about this? Or not necessarily in this instance with possessory title, but just things like, say, for example, they were requiring a site with possessory title, but looking at bigger issues. So say, for example, I don't know, there was like rights of way or restrictive covenants or options. And it's saying to people, actually, have you thought about 5, 6, 7 steps ahead and what you need to do? Because I get called too late often, and And actually, I could have actually helped people prevent stuff earlier on. In terms of time and cost, it would have been much smaller and much easier to deal with than later on. So it's just use us not as like the last kind of step in the path, kind of bring us on earlier on, and work with us rather than just go, oh God, it's all gone peak tone, right? Bring in the litigators. So that's just my plea in general. Because I think people don't know when to call us, and I would rather people would actually just call us and like chew the fat and say, I've got this problem, or my client's thinking about buying this site. I've got these potential things. What are your thoughts on it? Is there anything we can do to like preempt a situation or to minimize the situation? So that's just in terms of like the bigger picture in terms of litigators and when we're kind of relevant. In terms of kind of moving on, one of the bits I deal with is obviously dilapidations. And one of the questions that we got asked was that if you're a tenant, should you do the works or seek a negotiated settlement? This is a really interesting one. Completely depends. Here you go, there's your classic lawyer answer. It depends, but it does depend. So often I will say to tenants, if they're dealing with a potential dilapidations claim, is first of all, understand what your dilapidations liability is in respect of the property. Often they don't read the lease, they don't understand what it means, what the yielding up provisions, what the repairing obligations are, if it's an onerous obligation or not. So at least go in with your eyes wide open to understand what the actual nature, extent, and scope of what those liabilities are. And then you can take an informed decision as to what you want to do moving forward. So what I would do if you can is to try and have an earlier conversation or as early a conversation with the landlord as possible to try and ascertain and scope out what their intentions for the property are. Because that is actually questionably more important than what your intentions as a tenant are. Why? Well, so there's a thing called Section 18 defence, which is it's not a golden ticket for a tenant, but
it's a dark art. Yeah.
It's a darker, but it's so important. So basically, Section 18, in a nutshell, is a defence to a dilapidations claim. And that's on two aspects. One, basically, if the landlord is going to substantially redevelop or demolish the property, that would render any dilapidations liability null and void. This is a very, very high level here. There's a lot more to it than that. And then the other aspect to that is if the landlord is not intending to put their hands in the pocket and actually do the works, then you can rely upon Section 18, and it's called the diminution in value of the reversion. What does that mean? It's basically that the landlord's entitlement to a claim against a tenant is not based on the cost of works to put the property back into the repair. It's a difference in value to the property as at that date between its current state of repair versus if all the repairing works and the obligations under the lease had been complied with. And it's a difference between those two values, which is the value of the claim that a landlord could bring. Now, that might be zero. That might be half of whatever the cost of works were. It could be the same. But it's so important, and that's why I say if you can get that dialogue with the landlord as soon as possible to understand what their intentions are, then in terms of like think of it as a game of poker, you work backwards because you know the hand a bit better that you're being dealt with. And if I was acting for the tenant, that's the first thing I would say to the landlord. And I'd say if you're not doing the works, then you need to get a Section 18 report, because then you're immediately potentially mitigating your liability. So there is an element though that some tenants are like super risk averse with litigation, and they just want to settle it. So they'll either try and do that by mitigating it by doing the works as much as possible, and then either get the sign off from the landlord to say that it's fine, or they try and seek a negotiated settlement. But I would urge caution before doing either of those two things before you try to scope out the landlord's position.
Is that so? One of the things I'm thinking about when you're talking there is it Jervis and Harris clause? So that's the one that allows the landlord to step in, isn't it? And
Yeah.
and do the works. How often are you seeing that in contentious practice now where they've stepped in to do works, and especially when they're in the current climate where people are avoiding
Yeah.
using Section 18 where at all possible. So
Jervis v. Harris is not relevant for terminal dilapidations claims. They can be dealt with for interim dilapidations claims, but they're normally used as a negotiating tool, what I would say as a wee prod to the tenants. So for anybody that doesn't know, Jervis and Harris clause is basically, it's a case which is a clause that's written into leases which allow a landlord to step in, do the works. You would give the tenant a reasonable time, generally 2 months, the clauses normally say, to say, here's a list of all the works that need to be done. If you don't do it within that period of time, then the landlord will step in and do the works. The key difference between that and a dilapidations kind of claim is that it's not based on damages, it's a debt claim. So what you would do is the, I suppose, level of mitigation and or defences that a tenant can bring in terms of a Jervis v. Harris clause is minimal compared to a damages claim for dilapidation. So it can have quite a good leverage more often than not. I think in nearly 20 years, I've seen it used once where a landlord has actually gone in under it. I've had, and then do it as a debt claim. I've had landlords threaten it and they be stopped from pursuing it under injunctions. I've had lots of threats of it, and just the threat of it and preparing a schedule as like an interim schedule of dilapidations will then bring the parties to a conversation. But again, with that, you have to just watch, because you have to look at the timings of it, when it's going to be done, both from the validity by the landlord, the enforcement, and then the recoverability. So it has its place.
So we find when we're drafting leases, and I'd hate to think anybody would do them all, who thinks we do them all from scratch straight away. We all know where we're going for a decent precedent lease. But when we're drafting and when we're advising clients, we're telling people what's in those. And it goes back to the good point you made, actually, is we as non-contentious lawyers don't understand the other side's position, or the litigated position. So, I'll be saying, oh, and by the way, as landlords, you can go in and do that. But then I'm not saying, but fat chance, or you're going to get an injunction, or and actually that's something really informs your advice to your clients. So I find clients that you've communicated well with are less likely to complain. So it brings me back to drafting around that area. So there might be a Section 18 cap, whether it's mentioned or not. So, you can have that, I suppose that, I'm trying to think what the case was. Early, is it 2012, 2013, something changed around that they could cap section, there was Section 18 cap.
What, you're talking about Sun Life?
Yeah, that's the one. That's it, yeah.
That's to do with betterment and supersession arguments.
Yeah.
So with that, that's slightly different. So the supersession argument and the betterment. So the easiest way to explain that is if you've got a repairing liability in a lease and it says, I don't know, like you've got to have it in good condition and repair, which is like one of the most onerous ones. And the landlord, and it's got mechanical and engineering liabilities. And the landlord, there's a perfectly serviceable lift in there as an example, but the landlords needs to upgrade and update the building. It's maybe was done in the 70s. They need to put better, fancy, jazzier lifts in or whatever it is. And they try to include the cost of all of that within the dilapidations liability. That's where in that case they said, hang on a minute, that's over and above.
Right. So even on a put and keep lease, that could be considered to be over and above.
Yeah, because there's a difference between putting it back into the standard that's required into the lease versus say for example, the doing the equivalent stuff was, I'm making the figures up, 100,000, but they wanted to put spangly, dabby-dozy ones in. It was £500,000. The courts would turn around and say, well, no, that's not fair, because you're basically trying to get the outgoing tenant to pay for your basically upgrades of a building, but that's out with and over and above their liabilities. So
Um,
the
and
cost would be capped at 100, not 500.
with a put and keep though, how does that work around it? So I'm thinking actually about all the pain we've been through with the Building Safety Act lately. On a put and keep, would things around building control, so bringing it up to standard for building control, would that be caught by that or not?
I suppose it depends on the wording again.
Yeah, yeah,
It
depends. Yeah,
depends,
I
depends on
can
the
I
wording
can
of the
feel
lease.
7 hours billing coming on there.
Yeah. And it depends what, say, for example, like if I was acting for a tenant, in your position, every single day of the week, I'd be asking for a schedule condition,
Yeah,
like detailed
yeah.
photographs, etc. If I was acting for a landlord,
You'd
I
be
would not be
resisting.
pushing
Yeah, yeah,
for
no,
that.
it's always been the same, I think.
Yeah.
And they come in and out of fashion, but that's generally been the way. And I mean, it brings me on, I suppose, to the next question that we've got, which is
Mm.
around one of the things that the Law Society are doing at the moment is having a look at their climate change guidance and
Right.
the race to net zero, so everything
Yep.
post Kyoto, and is a really controversial topic. And there's nothing as likely to cause an angry, non-contentious land lawyer at the moment than talking about this stuff. So what should we
Right.
be advising on? So we've got the MEES that's tightening. We've got the idea of green leases coming up more and more. So what's going to need to be happening with these leases? So some of these are a sales tool almost.
Mhm.
We're providing a green lease. Some people want to be involved with that. Some people don't give them monkeys. But we've also got the situation where EPCs, so the energy performance certificates, the standards are going to have to be higher. So we've got minimum energy efficiency standards that prohibit landlords granting continuing leases under, this is where I get my resi and my commercial mixed. It's F4G, I think it is for commercials. Yeah, they come in, they look nice. I go, oh, okay, and then I cross-reference it, but that's about as far as I go, which is very naughty. That at the moment is really the starting position. So, I was just having a look at some of this the other day. So, we all non-domestic buildings are going to have to reach an EPC
Mm.
B,
Mm.
which most Victorian buildings can't achieve.
Yeah.
Literally cannot achieve. You're not going to get past a D where you've got double skin, no cavity, possibly. So that's 2030, and they're looking at EPCC by 2027. So you
Mm.
can imagine what we're doing with some of the stock we've got on at the moment. So we're making future compliance with these things are very much part of our planning now. And that puts litigators in a really difficult position advising on that, because we don't know from either from a litigated position or from a non-contentious position how people are going to deal with that. Clients are going to be left with a lot of stock where they are either going to have to make vast improvements. Are they going to be looking to, with their put and keeps, for example, are they going to be looking at putting that onto some of the tenants? So
Mm.
I'll be interested to see what happens that. So we've
I think with that sort of thing as well, from a litigator perspective, if we haven't got any legislation that helps us, then our second port of call is the case law. Um, and we don't, there's like
there
a
isn't any.
natural timeline to these sorts of things. They've got to be go into the leases. The leases have got to then come to an end, and then there's got to be an
Mhm,
argument over the
mhm,
kind of the interpretation of
mhm,
it, and then we get the case law. And the court system's broken, frankly. It's so massively understaffed, underfunded, and
mhm,
overwhelmed
mhm.
that everything takes ages to get through. So I think, well, you're ranting about figures of 2027, 2090, 2030. Like those things might be implemented, but I don't think the follow
We're
through.
not going to see it, yeah, for a
Like
while.
it'll be like a decade down the line after
Yeah,
that.
but from my perspective, and that I need to be thinking about those things now ahead of
Mm,
time. So I'm going to be looking at acquisitions where I'm saying to clients, look, this is coming. I
felt
don't
like
know
you're
how this is going to
retrofitting.
be. Sign my disclaimer.
Yeah.
Sign my disclaimer because I can't possibly know. And I think I've seen. I mean, our job is to advise. That there's no
Mm.
question. But in these sort of areas where we can't advise, and we don't know what the outcome, and we don't know how much appetite there are for these things going forward, the awareness that they might be coming, and to keep your clients fully advised and get them to sign on the dotted line to say, you can't say. I don't know how that would be perceived. If you come to the other end and the
No.
solicitor's saying, we don't know, sign here to say we've told you we don't know,
It's
would
really
be
interesting you say
perceived.
that because every single probably job that I do as a litigator, that is the every conversation that I have.
Mm,
Because we in litigation, if you give somebody as an example of 70% prospects of success, that is like nailed on. That is the highest you will ever get
yeah, yeah.
somebody in litigation to go. Because the reality is that we don't have a crystal ball and we can't determine what's going to happen. All I can do is say to people, this is from my experience, this is the case law, this is the legislation, and this
Hmm.
is the way that from talking to other people in my industry, this is what the approach seems to be.
Hmm.
Um, and I've had instances where it was like, this is nailed on. Like this couldn't go any better. Like if you looked at it on paper, we were winning. Goes into the witness box, all falls apart. And I'm like, oh, well, I didn't anticipate that one happening. And
Hmm.
it's like, so for us, I think we're far more comfortable with it because that's just our bread and butter. That's the reality that we can't give people certainty and what
Yeah,
we say to people. So I always say to my clients, it's not me taking the risk. It's me advising you on the risks. You have to decide what your appetite for risks is,
yeah.
and then we work backwards accordingly. And it's the same with dilapidations claims. If you're a landlord, for example, and you were wanting to um push hard on something, you're going, well, okay, I'm guided by what the lease says and therefore what a surveyor would interpret the liabilities to be.
Hmm.
But I know that I, for example, want to redevelop. But then you go, well, when do I redevelop? Because if I redevelop too soon or if I get my ducks in a row, then that could actually equate to Section 18 defense. Or, actually, I don't know if I am going to do it. And I do need to do the works because I need to upgrade the building in order to get a better quality tenant and better terms. But how much of that can I put against the outgoing tenant versus how
Hmm.
much I have to pay?
Hmm.
What's the tenant like? Are they good for the money? I had one a couple of weeks ago where the landlord had a strong dilapidations case. It was a scheduled condition. There was no issues there. And the tenant basically was like, I'm not disputing it really. However, I'm a charity.
Yeah.
I haven't got the money. And the client was like, oh, right, okay. So even if they've got a guarantor, like they didn't have a guarantor because it was a charity. It's a charity and they do really good work. Um, he's going to take the property back for himself. He was like, okay, so technically and legally, I have a really strong case for X amount. But actually, in this instance, with the whole mixture of everything and taking everything into account, and actually, this charity does really good work in my local area. If I push really hard for what I'm entitled to, I'll sink the charity and that good work won't continue. And actually, I'm going to take back the property. So I'll take a view as long as X costs cover what I need to do, then I'll do it that way. Now, that is like a commercial decision based on a whole lot of factors that was relevant to that client in that particular instance. And that is the reality in my world of litigation of, yes, there might be the technical, but what's the practical?
Mm.
And that practical is ultimately down to the client. And like I said, the appetite for risk, thinking about everything in the round.
Hmm.
My job is to say, these are the things that you need to
These are
consider.
the things, yeah.
And then
And
you
and
decide the priority.
yeah, and this is something that in non-contentious we're often guilty of, and that I wanted to talk a lot more in the in the teaching space over the next couple of years is actually we need to apply a much broader commercial brain on how we go about these things. And the point you mentioned about charities is a good one. That you get a charity as a client, they're going to pay their rent. They're not going to. The chances are they're going to be a good tenant. But if they're not, you've got a moral problem that really shouldn't be for us to advise on. But thinking about I hate the word holistically because it's bandied about too much, but actually thinking about your transactions from a holistic point of view and going, well, have you thought about this, this, and this, and then protecting our position from the profession on giving that advice is something that we on the non-contentious side definitely need to do more of, rather than
Right.
and because I think that there's very much the things I hear, both more from resi clients who get a bit well, let's call it passionate, shall we, but wailing down the telephone and things, because it's very emotional, but more so than we used to do from commercial clients, where they want you to hold their hand through their transaction, and I'm fine with that, as long as I don't overstep the mark. Knowing whose lane is which is really important. But thinking about it from a litigation from a moral perspective, I can have prevented a situation by upfront just going, and whilst you think on, are you going to want to sue these tenants if they really misbehave?
Like, look, my job as a litigator, and I was saying this actually incidentally this morning to a friend about something. It was actually to somebody who was they do investments, and it was about, she was asking me about the role of a litigator, and I was like, people think it's to draft claims and issue at court, and I said it's not. I'm like part counselor, part therapist, part the devil in your shoulder, part like
Key
your
woman.
wisdom person. I'm like, half the time I was like, the power of an apology is like phenomenal, and it's
the
so
right
useful.
apology at the right time.
It's I've settled 7-figure claims, massive mediations, just on an apology, um, because the ego was too involved, and people weren't looking at the bigger picture. And ultimately, you can have a really strong case legally, or you can have a really weak case legally. But if you are looking and understanding about what the ultimate goal is that people want to achieve, so that's always the first thing I say to my clients. What do you actually want to achieve? And then I'll work backwards and tell you whether it's achievable or not. And if it is, how we do it. But actually, like, I could give you 5 different outcomes, but you need to tell me which is the most important. And then we work backwards.
And that's for us, stepping away from the transaction, getting some heads of terms, looking and thinking, right, well, bang, 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 I'll do that. I'll fill in this form, I'll fill in that form. Is where we, and everybody can make drafting mistakes, but actually that is where we come unstuck quite a lot of the time, is that we're forgetting the human element of it. And and it's a really it is a really interesting way, that we are approaching things on a much. I mean, I'm not a betting woman, and this is the point. But neither should I be expected as a transactional lawyer to know all the answers all the time. Because nobody expects it. Nobody expects it from the contentious side. Because how the hell do you know? You're going to put it in front of somebody. Whereas we're expected to know, and breeding the confidence in the transactional lawyers to say, don't know the answer to that question, and you are going to have to make a commercial decision on, we've got this, this, and this, and using more legal advice rather than thinking we can just do it all via checklists. So so I think that because of me, I think we've gone slightly adrift from the questions in the order they were. I think because me's sat together with what we were talking about works. And I think we've drifted slightly away from some of the bits that we were being asked. So
well, why don't we have a look at, because both of us can talk about break notices, can't we?
Yeah, we can. It's a big one at the moment. It's break notices.
So we've got a couple of questions around break notices, but I'm just trying to think of a good one to deal with. I suppose, why don't we do the whole, like, you have been, I'm just thinking, I'm kind of merging a couple of questions here.
Yeah.
But there's a conditional break notice.
Mm-hmm.
when you are drafting it, actually, this is from my perspective to you as
Okay.
somebody who drafts it. I interpret it and make sure it gets either
Hmm.
complied with or not complied with. What makes you, or what informs what you put into a conditional break notice, a break option clause?
Um,
Like, what do clients, and you can do it from either landlord or tenant. I'm guessing it's always the landlord that would push for a conditional break.
mhm.
What would they want to do? What do they know? What do they
What
see
what what do
the
they
benefit
normally
of?
say? I mean, landlords. It depends who the break is. I mean, you almost never see mutual breaks now. It is pretty much. I don't know if you've seen one recently, but it is pretty much only tenant breaks. Um, because tenants want to know if they're running a business out of somewhere they can, they
Yeah.
can manage it. So um, tenants are going to want flexibility, clean break, minimal obligations,
Mm.
and to know that in all certainty it can work. You serve your notice, Bob's your uncle, doesn't matter whether you leave anything in there or it doesn't. Landlords generally do agree breaks, usually 3-year breaks,
Yeah.
on anything of a reasonable length. So, but they need to protect the commercial interest. So they are thinking about it from different hats. So I'm just thinking about standard. What's going to be standard? So rent, payment of rent.
Yeah.
So you're not going to be able to break if your rent and your service charges, your management charges aren't up to date. So what does it mean? What does rent mean? And this is why you see us
Mm.
holding insurance rent as rent. So
Yeah.
how we define our rental terms. So what was the where it was 130 quid? There's a
Oh, it's
case.
the it
PCE was it? Where there was
no,
it
it's the
cancer research or
NYK
something?
Logistics,
Right, okay.
where they and actually it's a tenant's own fault because A, they shouldn't have been so sorry, just as
Yeah, no.
like a thing. Basically, tenant tried to exercise a break. The landlord and they had been late historically paying rent, and the clause in the leases were very clear to say that they could be charged interest for the rent payments, and I think that was being defined, or the definition for the break was that they had to comply with all covenants in the
All
lease.
covenants. Yeah, that's the best of Eve case, isn't it? That one. Yeah.
And they were aware that they paid it, and then they asked for the landlord to confirm how much the outstanding rent was
Hmm.
and how much the outstanding kind of insurance late payment bits
Hmm.
were. And the landlord didn't reply. You don't have to reply.
Hmm.
The courts. So basically, the tenants didn't pay the right amount, and the courts held that it was they didn't hadn't affected the break. And the tenants, I think, appealed and it said, look, that's not fair because we'd asked them how much it was and they didn't come back to us. And the courts turned around and said, well, it's not for them to have to come back to you. A, you should
Hmm.
have been late in the first place. And B, if you were late, it very clearly says it's expert, I'm making it up, 5% above the base rate from the day it falls due, right?
Hmm.
So you can sit with the calculator and work it out. And if you're worried, you do that and you add 20% on and take a hit because it might be 50 quid or something, whatever it is,
Hmm.
and then there's no argument. But you didn't choose to do that, tenants, so it's your lookout.
Yeah.
That was basically it.
And I
But
mean, it can be. I mean, so covenants are compliance with covenants. I mean, it's risky, it's controversial.
it's
So that was that.
onerous.
Yeah, absolutely. And getting your notice right, making sure that clients know, because most clients don't understand what covenants are. The ways I have to go around, explaining covenants,
Hmm.
positive covenants, restrictive covenants, who does what, and understanding a title. But they think, oh, I'm taking a lease, but you've got this background stuff. You've
Yeah.
got to understand it. Um, and am I right in it's not reasonable or fair? It either it's black or white, isn't it? Look how the court interprets it. It is just black or white. It is or it isn't.
So with break notices, there's a very famous case where the judge says if it says it's to be written in blue ink on pink paper and served and sent with a red ribbon around it, then that's what you have to
You
do.
have to
If
do.
you don't
Yeah.
do that, then it's not
then it's not right. Yeah,
neither.
yeah. So there's
There's
no
no dividing.
subjective. There's
No,
no,
there's no
yeah.
50-50 grey on this one. It's
Um,
very clear.
so I mean, when we're drafting and um, you know, most of us have got really good precedents. I mean, you do see some interesting things cobbled together by people who think landlord is for the witless and that they can do it themselves, you know. So keep I'm telling people to keep conditions minimum, make sure you've paid, and use, you know, make sure my definitions are really clear, and you know, try and broaden the scope for what, you know, from a tenant for what constitutes notice, and making sure that landlords have got to respond to it. Landlords, it's around protecting genuine commercial interests, so not them being contrary or trying to make breaks not function, and making sure clients understand that they have to satisfy all the conditions before the break date. So it can be at the time the notice is served. So otherwise you get into estoppel territory, and Lord knows I don't want to advise anybody on that. And the Capital Park case, I'm just going to try and get some details up while because this is the one the Leeds one. I should know it, shouldn't I? I'm only up the road from it. About vacant possession, about what constitutes vacant possession.
Yeah, so
So
with that,
if you're leaving your panels up, tough, you know,
so
tough luck, your brake's not worked. Yeah.
so what you have to be very clear on is what the yielding up provisions state
Hmm.
within a lease. And you have to read that in conjunction with your repairing obligations and also the conditions of the break. So the break is conditional upon VP, vacant possession, being provided. You have to be very clear and understand the nature, extent, and scope of all of that encompasses. It's not, you have to also sit that against chattels, tenants, fixtures, and fittings. Sometimes with the yielding up obligations, it will put a positive duty on the landlord to confirm if, for example, they want alterations or additions removed that the tenants have put in, or that they have to kind of do a positive step for either something to stay or something to be removed.
Yeah.
So again, with all of this, it's about early communication with the landlord as much as possible to have a collaborative discussion. Because what you often will maybe find is that if the lease might, for example, say that everything's got to get stripped back to basics, but a landlord might turn around and say, well, actually, I have a better chance of letting it out with some
With some of
partitions
that.
and other bits and bobs that they might have
Hmm.
done. So actually, I'm quite happy for the tenant to leave that in situ. Now, that works well for both parties because it means the tenant doesn't have to faff about worrying about getting it removed and any question on the compliance. The landlord gets the benefit of a more, shall we say, fitted out unit for the purpose of reletting, and they aren't at the costs. You just make sure that you document it. So you
The
have those early conversations as much as you possibly can.
and I think that's really important, actually, particularly for that case, because overstrip was a point.
Yeah,
So taking too much away
yeah,
and leaving landlords with I mean, slightly ridiculous, with a shell
yeah, yeah,
is
yeah,
it could be mean that your brake's not effective. You know,
yeah,
if you've not complied exactly,
yeah.
and then that's going to give you a delapse problem.
Absolutely. It's and actually I had a contested trial dilapidations claim. Gosh, I was just new trainee becoming newly qualified many moons ago, and it was a mill up north, and the tenants had stripped it out to the extent of stripped out the copper wiring, like the
Yeah,
whole kit and
yeah. So yeah, overstrip. Yeah,
but they'd rendered it uninhabitable and uninsurable as a result. And they were trying to defend it on the basis of Section 18 defence that we were going to turn it into housing, basically. And so therefore it didn't matter. But what they didn't have, and this is going slightly back to the dilapidations, but it was a perspective of they stripped it out so far that they'd gone so beyond it. But actually, we didn't have a fixed and settled intention to demolish or redevelop. We didn't have the funding. We didn't have planning permission. We didn't have all the things that you need to have to show it. But they didn't listen to any of that, and they still tried to get around it. And then we were left in a position with we had a building that was worth X that had been I don't know, at least 40% knocked off the value because of all the works that the tenant had done. And interestingly, you know what, how that got settled?
Go on.
My client, who was a tenant, because it was a business and it'd been bought by a conglomerate in Switzerland, I think it was, or Germany, had phoned the CEO of that company and said, "Do you know what's going on?" They were in trial, and because it was all different subsidiaries, they didn't know. And the CEO was like, "I had no idea," was mortified. Like within a couple of hours, the whole thing had been settled, all additional costs had been paid, handwritten apology, and quite a few of the people from the original company that had stripped it out all got sacked.
That's the golden rule of if in doubt, tell your dad. And it's the solution I use. I've not tell my dad because I don't think he'd care anymore. But frequently when things are going adrift with, I will go straight to the CEO of something and get a
Yeah.
steer on it because some of these things can get misinterpreted, and that's really quite interesting. I'm just looking. Then we talked about you get the litigation and the transactional lawyers speak to one another where there are knotty problems. There are times when it can't just be lawyers; we have to get the surveyors involved. So
Oh,
I think
my job
you were
is
asked that one. When do you tell them? When do I tell them?
so for me, in dilapidations and they are an integral part. It's a tripod effect. So it's the lawyers, the client, and the surveyors. I'm not an expert on buildings in terms of the compliance with the terms of the lease. So my job, I'm very much guided by them in terms of them preparing the schedule of condition and or responding to a schedule of condition. You need them for expert reports for either the dilapidations claim itself, and it has to be signed off by them. They've got their reporting obligations. But you've also got, if it's a Section 18 valuation report, that would be carried on by an expert. And I am guided by them of what are the big ticket items? What are the ones that are like 50-50? Where's our strong areas? What bits can we do we have to take a view on? Again, it's all about risk management. So for me, when anybody comes to me with either landlord or tenant hat on with surveying, with the dilapidations claim, then I'm like, first thing I say is, who's the surveyor? Who have we got? And let's have that conversation. And almost the first conversation I'll have is with the surveyor over the client to find out the strengths and weaknesses of the actual claim from the technical bit. And then I'll say, right, let's have a three-way with the client to understand the commercial intentions and where we're at. But they are super pivotal, critical, and they're an integral third part in my tripod.
And what absolutely where my side of it seems to go adrift is we treat them like estate agents. And
right.
Yeah, okay. So here they go with their heads of terms and giving us a hard time because we've not exchanged contracts yet because they just want paying, which is of course they want paying, but not really the point. There are so many times throughout a transaction, pre-exchange, completion, however we're going about it, where clients should be advised to get surveyors. If you're getting a full repairing and insuring, if you're getting a put and keep, okay, schedule a condition is one thing, but actually stepping away from giving advice on structure or making sure that we're getting clients to understand what the value is, because if you've had surveyor involvement at that point, there are less likely to be arguments at your point. And we don't utilize them enough. I think is at that end of the transaction. So getting them involved at heads it is ideal. The advising on layout, EPCs, service charge forecasts, floor measurements.
But the surveyors, so when I do a lot of lease renewals, and that's like a four-way because there's myself, there's a surveyor, there's a transactional lawyer, and then there's a client. And so it's not me or the lawyer that agrees what the heads of terms are. By that, I mean in terms of they're the ones that understand the market. They're the ones that have got the comparables. They're the ones that are saying, actually in this market space, you can push harder for a contracted out 5-year lease, 3-year break,
Yeah,
and the
yeah.
square footage is X, Y, Z in that area. Or actually, do you know what? That's a really, really good offer. Now, that's where I truly believe it's really important to have your team. And it's a wee bit like doing a ceilidh, like you dip in and you dip out depending on whose turn it is of the dance.
Like a
But you,
drunk version of Strip the Willow is what it's
yeah,
like. If you're gonna go, Kaylee,
yeah,
it's the full.
exactly.
Yeah,
Yeah, so
yeah.
that you understand. You might all be on the group email, but you'll be like, so I tag team constantly with them
Mm,
because I'll be like, right, okay, I've done my bit. Now, guys,
hmm.
you need to go and liaise with the other surveyor, work at your comparables, tell me what the terms are.
Yeah.
Let's put that in the notice because I don't know what the terms should be for the rent. Um, and then, or if we're doing like a rent review with that sits
Hmm.
alongside like a commercial lease renewal,
Hmm.
then I need to know what the past rent review kind of situations may be. Well, I'm not a surveyor. I can't tell you.
And equally, we can. So I've got one on further south at the moment where we're doing a renewal. Tenants are misbehaving. There was a final day rent review in the expiring lease. Still protected under the Act. Well, I'm able then to tell the surveyor that that's there to go off and and do the final so that we can backdate.
Yeah,
Making putting my client, the landlord, in a better position. So that on the ongoing access, the number of times, Simone, that I am asked to negotiate heads. You just,
really.
yeah, particularly for small clients, because they'll say, "Oh, we want to do this. Will you go ask them?" No, you need to pay a surveyor. Well, the surveyor's going to cost
Yeah,
X, Y, Z.
but think
Push
about it in the long
back
term.
hard. Yeah, that's so. But what for me, yes, that's easy enough. I know how to push back but for a lot of particularly young lawyers who um are learning how to do these things, it's not always easy to push back against the client and go, not my job, not my job. And you suddenly find yourself going in, and there's a lot of advice I give around, because sometimes I'll see heads of terms come in where an unsophisticated client's been encouraged to sign up for something on heads of terms, and I know that doesn't suit my client, so I'll be pushing back because I'm having to advise my client. There's a very fine line to tread then between me having negotiated terms and me saying to clients, come on, this is not quite right in this. So actually having a surveyor in your arsenal as part of your team, even if they're not on this job, is
So
often a really good idea as well. So,
definitely. And like I'll say to a client, say for example, on a dilapidations claim, if and the landlord said that they're not doing the works. So I'll say to them, you need to get you need to push for a Section 18 valuer, and then you need to get yours to do the response. And they'll go, yeah, but they'll cost me 2 grand. I'm like, they'll cost you 2 grand, but they'll probably save you 20 grand.
mhm.
You need to understand
Yeah.
that you've got to
Yeah,
spend
when it
to
hits the
save.
fan, this
Yeah.
is when you look back and think, I wish I'd spent the
Well,
£2 grand.
I say, who do you want on your team? The person that's going to negotiate and save you the most money,
Hmm.
in which case that's their specialism.
Hmm.
Because I can't
I have
negotiate
no
on a
idea.
spot schedule. And
Yeah,
I'm not a surveyor.
yeah.
Just like they can't do what I do. But if we do it together and we step in and out accordingly, then you get the best of both
Client's getting
worlds.
the best outcome. That's
And,
right. Well,
and it's
that's
just
right.
having the confidence to say no, buy cheap, buy twice, and
Yeah.
don't don't
Or
skip
I
this
mean,
month.
say that we touched on it before. Well, if you won't do as I say, sign my disclaimer. Usually
Yeah.
focuses the mind,
Mhm.
but I've done the job for a long time. I'm very
Yeah.
confident,
Yeah, yeah,
and I want to, I want to make sure that other lawyers feel comfortable with doing that, because when it hits the fan, your job is easier because
absolutely.
the transactional
Absolutely.
side have looked at. I'm just looking at time,
I
and
know,
I'm just
I think,
looking at what else. We've got quite a lot that we could have been talking about, but I think we've bulked some of it together.
yeah,
We've not had a look at service charge certificates and things like that were on
that'll
our
be for another
on
day.
our agenda, but I think it'll take us far too long, won't it? And
Absolutely. I think it's just time for us to do the final comments, really. Do
it is. So
you want to do it or shall I?
you do it.
Okay, okay. Well, in which case,
Need a lozenge.
That's all we have time for today. Thank you for attending the Law 2025 online commercial property Shape the Debate. If you would like to submit a question for the next Shape the Debate, don't forget to sign up to receive emails from the solicitors group and be notified of future sessions. As mentioned at the beginning of the session, there is still time to book and watch full pre-recorded content from this Law Online. This law event package is accessible for 90 days from the day of purchase and allows you to learn at a time and a place convenient to you. You can book or find out more about this event by going to the Solicitors Group website at www.thesolicitorsgroup.co.uk. Finally, don't forget to fill out your feedback form once you've completed your Law Online webinars. By completing this, you will receive your CPD certificate. Thank you again and have a great day.
Thank you.